So minus 7 is 64, which is good.
Yeah. Yeah. And I'll start the webinar in 3, 2, 1. Yes, sir.
Good evening, everyone.
One sec. Just I think people are still logging in. I'm just seeing 34 number.
Yeah,
Just give me a couple of seconds for to at least one lot to come in. Yep, Dhanashree, over to you.
Good evening, everyone. Thank you so much for joining us today. I'm Dhanashree Gavankar, and it's a real pleasure to welcome you all to this important virtual session brought to you by the Indo-American Chamber of Commerce, West India Council. Today, we are focusing on a topic that holds significance for many, from students and professionals to businesses and policymakers. This session is titled US Visa Barriers, Impact on Indian Travelers and Businesses. Our conversation today aims to offer clarity, share experiences, and explore the evolving landscape of US visa processes and what it means for Indian mobility, business planning, and compliance. We have an excellent panel lined up, and we encourage you all to take full advantage of their insights. Please feel free to share your questions in the Q&A box throughout the session. And to get us started, I'd like to invite the President of IACC West India Council, Mr. Nilesh Vikamse, to deliver the opening remarks. But before we hear his thoughts, allow me to briefly share a few words about his remarkable leadership and contributions. Mr. Nilesh Vikamse is the current Regional President of IACC West India Council and a senior partner at KKC and Associates LLP, an 86-year-old chartered accountants firm. He serves as an independent director in several listed and unlisted companies and is involved in various organizations, including core group member of the Bombay Chartered Accountants Society. He is a trustee of several educational trusts in Mumbai. Additionally, he is a member of the Advisory Committee on Mutual Funds at SEBI and the Expert Advisory Committee of ICAI. He has served on numerous prestigious boards, including the International Federation of Accountants, the Federal Bank, and the IRDA. He was the past president of ICAI. And also, Mr. Vikamse was the chairman of SEBI's Qualified Audit Report Committee and has been a key figure in various committees, including the Corporate Governance Committee chaired by Mr. Uday Kota. We are privileged to be led by someone who brings a wealth of experience, deep insight into global business dynamics, and a relentless passion for fostering cross-border collaboration. Please join me in welcoming Mr. Nilesh Vikamse. Over to you, sir.
Thanks, Dhanashree, for the kind words. A very good evening to everyone. Friends, we have been hearing growing concern from Indian travelers, students, and professionals regarding the current challenges surrounding US visas. There has been a noticeable rise in reports of delayed appointments, unexpected cancellations, and heightened uncertainty, especially in the student and work visa categories. These developments have created considerable anxiety, particularly for young students preparing to embark on their academic journeys in the United States, as well as for professionals and companies that rely on timely cross-border mobility to meet project commitments and business objectives. Hence, at the Indo-American Chamber of Commerce, we felt that we should have a session on this US visa-related issues right now. And I'm delighted to welcome you all to this timely and important virtual session, which is titled US Visa Barriers, Impact on Indian Travelers and Businesses. We are proud to host this high-impact discussion, which brings together legal experts, business leaders, and policy observers to share valuable insights in the evolving US visa environment, a matter that has significant implications for Indian professionals, students, entrepreneurs, and corporations alike. Over the decades, India and the United States have built a robust partnership grounded in shared values and strong people-to-people ties. Yet, as global policies shift and geopolitical dynamics evolve, visa frameworks, particularly those related to skilled talent and business mobility, are coming under renewed scrutiny. This session has been thoughtfully curated to explore critical questions around the future of key visa categories, potential legal strategies to navigate procedural hurdles, and the operational implications for Indian companies, particularly in the IT and the services sector, as also students. We also will also take a closer look at the alternative pathways like the EB5 investor and the golden visas as Indian applicants assess broader migration and investment trends in a changing global context. We are honored to have an esteemed panel of speakers today who are expert professionals in their own right, but also one common thread binds them all. That is, they're all connected to IACC in different roles. For example, Purvi Chothani is a past president of the West India Council of IACC, Indo-American Chamber of Commerce. Manoj is currently the part of the National Executive Committee of IACC, and Deepesh is my colleague as a committee member on the West India Council. The formal introduction will be followed by Dhanashree later, just to give their professional and corporate background. They will help decode the legal, regulatory, and strategic dimensions of this issue. Their experience spans immigration law, cross-border business operations, and US-India bilateral relations, ensuring that today's dialogue is both rich in content and actionable in impact. Friends, before we dive into today's proceedings, allow me to take a moment to share a brief overview of the Indo-American Chamber of Commerce for those people who are not members of IACC. IACC was established 55 years ago and has become a leading body dedicated to fostering and strengthening the economic relationship between India and the US. We are committed to helping businesses in both the countries understand each other's markets, identify emerging opportunities, and navigate trade barriers. Over the years, we have had the privilege of facilitating numerous bilateral trade exchanges, fostering investment partnerships, and supporting technological advancements. Through our efforts, we have built lasting relationships with key business, research, and development institutions, and continue to play a pivotal role in promoting cross-border collaborations that benefit both the nations. I would also like to take this opportunity to encourage those who are not yet members of IACC to become members. By becoming a member, you will gain access to wealth of exciting and informative sessions like today's, along with numerous other opportunities to connect, grow, and expand your network. Once again, thank you for joining us. We look forward to a very highly engaging and informative session. With that, let me hand this back to Dhanashree to take the proceedings forward.
Thank you, Mr. Vikamsi, for your valuable guidance and for setting the tone of today's discussion. It is now my pleasure to introduce our first speaker, Ms. Purvi Chothani. Ms. Chothani is a US immigration attorney and founder of LawQuest, a dynamic global immigration and Indian employment law firm. Her firm provides with setting up operations in India, guiding them through FDI and state regulations to ensure a high level of compliance. Ms. Chothani has spent years advising Indian professionals and companies on US immigration matters, especially work and family-based visas, as well as investment options like EB5 program. Her strategic legal guidance and client-first approach have helped many successfully navigate complex immigration processes. Ms. Chothani, we are looking forward to hear your thoughts.
Thank you so much, Dhanashree, for your nice and generous introduction. Thank you, Nilesh, and the current IACC committee for organizing this event and for inviting me to speak. I'm delighted to be here, and I'm delighted to have you all in the audience join us. Whether you are business owners or whether you are HR professionals, employers, or simply somebody who wants to travel to the United States, or a student, or a family member of such a person, this is a place where you'll get answers to many of your questions, especially those that have been thrown out by the media in India. I'm talking to you from Florida today, but I closely watch the Indian media about how they are talking about US visa and immigration processes. There is a lot of truth in what they're saying, but there is a lot of fear that is being created by their reporting. And I hope that after today's session, you will walk away with some ideas on how you can navigate the system. Yes, there are challenges, but there are ways to work within the system legally and achieve your goals and visit the US when you want to. Hope to address your questions as we go along. Thank you.
Thank you, Chutani. We truly appreciate your valuable thoughts and we look forward to dive deeper into the topic. Next, I'm happy to welcome Mr. Manoj Balwani. Mr. Balwani is the Executive VP at CTS Tech. He leads their procurement, admin infra, immigration, and travel functions. With over 39 years of experience, including 17 plus years in CTS Tech, Manoj has held senior roles across industries like IT, logistics, and textiles. He brings rich insight into cross-border talent movement, especially in the tech and healthcare sector. Mr. Balwani, over to you.
Thank you. Am I audible and visible to everyone?
Okay.
Yes, you
That's
are.
great. Okay, so thank you very much for your kind introduction, Dhanashri. Good evening, everyone. I'm honored to be a part of this important discussion hosted by the Indo-American Chamber of Commerce. As a healthcare IT firm with a strong US presence, we've seen firsthand how visa policies shape business continuity, talent mobility, and client relationships. Today's conversation is very timely as we navigate a dynamic immigration landscape under the new US administration. I look forward to sharing practical insights, listening to diverse perspectives here, as also exploring how we as an industry or as a country can adapt responsibly while continuing to build bridges between India and the United States. So really excited to be here, and we'll be happy to answer questions after this session. Yeah, thanks.
Thank you, Mr. Balwani. You've got us tuned in and we are really excited to unpack these points further. Moving on to our next speaker, it is my pleasure to introduce Mr. Deepesh Deshmukh, an immigration expert based in Mumbai. He's the founder of D Square Global Private Limited, and they offer the most comprehensive immigration solutions that are customized as per your needs. He provides immigration assistance to get US green cards in 1 or 2 years through the EB5 program. Mr. Deshmukh used to live in Boston, USA. He has been interviewed by various podcast channels, aggregating to over 70 million views. With over 20 years of experience in immigration industry, his sole purpose is to help people achieve their migration goals with ease. Mr. Deshmukh, we are really eager to hear your opening thoughts.
Thank you so much, Dhanashri, and it's an absolute pleasure to be on this panel. And a big thank you to the IACC leadership for organizing this program at such a critical time where people are worried, people are scared. But frankly, it's not as bad as it sounds because the media at times makes it sound bad. But we are here to, help you navigate through your questions. So we'll be more than happy to answer the questions at the end. But this is a time where, so a lot of people are saying, oh, new laws, they are just implementing some laws. And that is what is scaring people. So we will deep dive into all of this as we go ahead. But thank you so much for the introduction, Dhanush.
Thank you, Mr. Deshmukh. That's a great starting point to build on. And it's already sparking a lot of curiosity amongst us. And friends, we will now move on to the main discussion. And to moderate the session, it is my pleasure to now invite Mr. Raghavendra Pongshe, Vice President of IACC Western Region. I would quickly introduce Mr. Pongshe. In addition to serving as Vice President of the Indo-American Chamber of Commerce West India Council, he is a second-generation entrepreneur, IP advisor, strategist, and investor. As managing partner at Bhatia & Pongshe, a leading IP law firm founded in 1965, he advises clients in India and globally on patents, trademarks, designs, and copyrights. He also guides businesses on IP commercialization, strategy, and family business succession. Over to you, Mr. Raghavendra Pongshe, and I would also like to welcome back Mr. Nilesh Vikamsingh, who will be co-moderating the session with Mr. Pongshe. Over to you, sir.
So thanks, Dhanashri. Now, friends, we straight away deep dive into the various questions we have collated for the esteemed panelists. And I would request those of you from the audience who have got questions, please put them on the Q&A section of this. After we finish the questions which we already curated for all of you, if you still have any doubts left, I think you can put them and we'll try to address as many as possible within the given time frame. So let me start the session. And Purvi, I think the opening batsman would be you, since you're an expert in these areas. My first question to you, Purvi, is how is Trump's second presidency reshaping the US visa policies, particularly the B1, H1B, and the L1 visas that are vital for Indian professionals?
So thank you, Nilesh. Yes, that will be a good place to start. So first, let's understand what President Trump wants to achieve in his second term. He wants to make America great again. So that's his acronym MAGA. So everything that he's doing is with a view to make America great again. And part of his initiatives are to increase national security, keep America and American resources for Americans. And then to achieve that, he has tightened some of the immigration rules, canceled some of the immigration programs that gave large financial protection and asylum and refugee to individuals in the United States. He stopped some of those programs. And he has, like Nilesh said, and Dipesh said, tighten some of the laws that already existed. So I'm going to just walk you through some of the things that we are reading about in the media just now. So the first thing that I want to talk about is registration post 30 days in the United States. The government now requires everybody who has not been fingerprinted to be registered within 30 days of arrival in the United States, or 30 days from April 12, which is when this program kicked in. Now, do you need to register if you're going to be in America for 30 days? Most likely not, because you would have gotten a visa. And when you got the visa, you must have given your fingerprints, because without that, they're not going to give you a visa. And when you arrive in the United States at the airport, also you would have given your fingerprints and been issued a form I-94. Once you have these three ducks in a row, you are considered automatically registered. So there is no additional registration requirement. A word of caution over here. If a family traveled to the United States as H-1B worker and H-4 dependents, and the dependents arrived in the United States before the age of 14, they should speak to an immigration attorney to check whether the child needs to be registered or not. Because minor children have to be registered by their parent, and 14 years and up have to register themselves. You've got to check whether they need to register or not. But otherwise, if you have a visa and you've traveled, you're fine. You don't need to register. So anybody taking summer vacations or going to the United States to drop their children to university, etc., I don't think you need to worry at all. Now we come to when you arrive in the United States, there's a lot of talk about your cell phone and your mobile, your laptop and your iPad, any mobile device, any portable device being checked. Yes, the government has the right to do this, and they've had this right to do since policy changes after 9/11. So it's not a new policy, it's just being implemented more strictly and more widely. So what happens is they either will call you and ask you to show your mobile phone or laptop if it is a random check, and usually it's a random check, or if they have cause to believe that you may be somebody that they need to scrutinize further. So to give you an example for somebody who needs to be scrutinized further, about a month ago, there was a US immigration attorney who was returning from the Latin American countries after a trip with the family. And he was put into secondary interrogation, and he was an American citizen. But yet they asked him to show his mobile phone and devices. He had a choice. He could have said, no, I'm not going to show it to you. And he could have waited there for hours, which I believe he did for a while. And then he gave them limited access, because as a US citizen, you have a right to limit your access and get your device protected by attorney-client privilege protections and technology to protect that. But if you are somebody who's traveling on a visa, or if you're a green card holder, you have less rights. As a visitor, you have almost no rights to refuse that. If you refuse it, they have the right to put you on the next flight back to your country. So you must cooperate with them. So what should you do? How should you travel with your devices? If you are a legitimate business person or a traveler or a tourist or a student, you have nothing to worry about. You should only worry about it if you're, let's say, you are a journalist or you are a professional who gives a lot of opinions, and you've been giving opinions on things that the US government perceives are a threat to national security or American values. So anti-Semitism comments or comments in support of the Palestinians, etc., are considered by the US government to be anti-American. So you need to be careful about those type of things. But like I said, if you're legit, you're fine. Even as a journalist, if you're commenting on all these things, you may not be allowed into the United States. Now let's look at, suppose you're going for your visa. They're going to check your social media when you go for your visa. And this used to be very sporadic before, very rare, but now it's becoming more prevalent. So you need to be careful about what is out there on social media. Even if you go and delete your past posts, they have technology to access deleted posts. So sorry. Be careful about what you post in the future. You can't take care of the past, but be careful about what you post in the future. Even a simple like or a repost of a comment could get you into trouble, and your visa may be denied. So be careful about what's there. Then we come to extreme vetting. Every visa applicant and every petition that is filed with the US Citizenship and Immigration Services is subject to extreme vetting. What does that mean? That cases have to be scrutinized in more detail now and more deeply than before. Sorry. What this means is that things that they may have glossed over in the past or they may have ignored in the past will not be ignored anymore. Not only that, when you are filing for renewals for your H-1B visa, etc., or your H-1B petition, etc., they're also checking your background against other police data and other government data to see if you have violated any law. And then if you have violated any law, even if it's a simple drinking under the influence of alcohol, you may be called in for fingerprinting, extra fingerprinting, and you may be questioned further. And yes, there is a risk of your visa being cancelled and you being sent home. So that is all part of extreme vetting. Now let's come to student visas. I'm just going to finish student visas and I'll finish this portion of my answer. So there's a lot of anxiety around student visas just now, and rightly so, because there are certain things that are impacting them. One of the first things that is impacting them just now for people who are seeking a visa is that they have stopped granting new student visa appointments. And that is just a temporary thing. It's not a permanent thing. They're doing it because they're setting up systems, technology, and processes to vet social media posts of all applicants. Not only students, but all applicants. But just now they're focusing on students because this is student season. Most students who are going to study in the United States start their term in August or September, and that is why they have started with this, is my opinion. They haven't announced it, but I think this type of thing will be coming even for other visa applicants. So that's the first thing for visa applicants. Now we talk about what happened a month ago. There was a spate of visa revocations and student F1 status termination. There's a difference. A visa is revoked by the Department of State, and the student status is revoked or terminated by the Department of Homeland Security. The Department of Homeland Security has a portal, a technology called the Student and Exchange Visa Information System. It's called SEVIS or SEVIS. And they track all international students on this portal after 9/11. And this service portal, I believe, was linked or was run through with other databases that have criminal records, police records, etc. And anyone who had a brush with the authorities or had any criminal interaction or any activity like that, their status was terminated. That is within the United States. And if you had a drinking under the influence of alcohol, etc., your visa was also revoked. So you could have either been subject to one or both of these terminations. However, after a litigation, the terminated students in the United States were reinstated until further action. So basically, they're safe for now. Are they safe fully? We don't know. I believe they're safe for now. And whoever can graduate and finish, it's a good idea to do so and maybe not avail of OPT or something, because the future is a bit uncertain just now, especially if your record is troublesome. Now we just will touch upon Harvard and Columbia University. The United States government gives millions of dollars as grants to these leading universities. And not only that, all these universities have to follow the Department of Education's guidelines on discrimination, racism, etc. And if they don't do that, their accreditation may be cancelled. Harvard had been asked to provide information about certain students and programs, which they did not do because they said that that is not part of the service compliance requirements. And then there is a litigation going on about that. But at the moment, students who are in Harvard are okay. But students who are applying for visas to go to Harvard may face trouble, because a few days ago, the Department of State sent a cable to all consulates across the world, not only India, about putting a pause on visas to Harvard until they do an extra checking on each applicant. So this could be a student, a professor, a parent going to drop a student to Harvard. Anybody who's visiting Harvard could face visa adjudication delays. So you will get a 221G notice and you will wait for that. And we don't know whether Harvard is going to be thrown out of the CVIS system. And if it is, then they will not be able to issue I-20s, that is the sponsorship letter for students in the future. We have to wait and watch. There are serious litigations going on about this. And my sense and the sense of the legal community is that some of the things will be thrown out on technicalities, because the fundamental question about freedom of speech would have to be decided by the US Supreme Court, and that could take time. So we've got to wait and watch. The latest thing that happened day before yesterday is to Columbia University. They also have received a notice from the Department of Education asking for certain data because of the October 23 protests or actions on their campus when there was the Palestine-Israeli interaction in 2023. So Columbia is also going down that road. Will this affect other universities? Yes, most likely. So if you're not going to one of these two universities, even then you need to watch the space carefully, because we don't know which university is coming next, and we don't know how strictly they're going to enforce their anti-racial policies, etc. So that's all for now, and I'm happy to answer questions. I just want to make one last comment. Everything I said just now applies to applicants across the world, not only Indians. So Indians don't need to fear more. It's not targeted as us, it's across the world. There are certain countries and the nationals of those countries have been banned from entering the country. This is as of yesterday or late day before yesterday, and India is not on that list. So don't worry about that. Okay, over to you.
Yeah, thank you, Purvi. This was very insightful observations and specific clarifications from you. Because the media, as you rightly said, we're getting different aspects from the media. Probably some fear has been infused, I would say, right? But these clarifications that you have given are very important, and they have clarified a lot of doubts at the start of the session itself. Coming to you, Manoj, I would like to take your views on how are Indian IT companies preparing for a possible tightening of US work visa rules in terms of talent deployment and workforce planning.
Yeah, am I audible?
Yes.
Okay, so Raghavendra, that's a great question and very relevant also, I would say, at this point. Thank you very much for even asking it. But before I attempt to answer it, I want to just spell out some of those tightening circumstances or visa rules that you are probably alluding to. Foremost among them are the unpredictability in visa adjudication timelines, increased scrutiny during the visa interviews, evolving documentation requirements, etc. For instance, requests for evidence, which is popularly known in our immigration parlance as RFEs, have become more detailed, requiring companies to invest in more robust documentation systems. Additionally, policy shifts such as what Purvi just mentioned, the pauses in the student visa interviews and the expanded social media screening, all these have obviously added layers of complexity. Now, coming back to your moot question, how are we preparing? Well, the first and foremost thing is we as a company, what we are doing as a company is that we are making sure that we are always aligned with the latest rules in force. Compliance is foundational. So since inception, we've always been a very fully compliant company, and our endeavor is to maintain that highest level of compliance. You will agree, Raghvendra, that when you're fully compliant, you have nothing to hide, and therefore you have nothing to fear, right? You see, the benefit of this policy of complete compliance is that we are the least prone to visa rejections. And we are achieving compliance by strengthening our internal immigration compliance frameworks, which includes, for example, maintaining detailed documentation for each visa petition. Importantly, educating employees on permissible activities under each visa type. Thirdly, using centralized systems for immigration case tracking and for audit readiness, audits from the FDNS and from various other US government authorities. Regulating and, updating ourselves of all these latest visa rules and accordingly updating our internal policies in line with those evolving US regulations. And like I said, investing in automation tools to streamline document archival and retrieval of our various visa dossiers, etc. What we also do is we ensure accurate job descriptions, wage levels, and worksite disclosures in our visa petitions. And like I said, besides regular audits and legal reviews, these have actually helped us to avoid penalties and also to maintain trust with the US authorities. Now, whatever I mentioned so far, these are the inward directed measures. There are some outward looking measures as well, which we are usually using. And that is, we are increasing our emphasis on nearshore delivery models and hybrid work arrangements, through which the primary focus is or objective is how can we reduce dependency on physical relocations. So I'll leave it at that for now, and I hope this helps. Yeah. Thank you.
Thanks, Manoj. Excellent response. As any government or any regulator would say, they would, of course, make the rules, amend the rules, which is in the interest of the country. But as a corporate, what we need to do, how we need to strengthen the internal, I would say the documentation, the automation, whatever is required. I think that that's a great response. And other than that, how else near shoring, etc. I think good. I think this would have given a good feedback to the audience, which is there. Over to you, Dipesh. Dipesh, you have been in this immigration advisory for last 20 years or so. So how do you anticipate a renewed interest in the EB-5 investor visa route amongst Indian families and professionals in response to the H-1B uncertainties as we understand right now?
So H-1B uncertainties were always there. A lot of people don't know about the laws, the nitty-gritties. H-1B is a work permit. An American company hiring a foreign national gets H-1B. It's typically a 2 to 3 year visa for the first time, and then you get one renewal of 3 more years. After that, the law says that you have to step out of US for 1 year and come back on a new H-1B, provided you get your name once again in the lottery, right? So this was always there. And of course, if somebody files for a EB2 category green card and they get an I-140 approval in 2 to 3 years, then they can renew the H1B till the time they get a green card. The only issue is the Indians and Chinese, the number of applicants are so many that there is a 40 to 50-year wait if you file as a H1B visa holder, a EB2 category green card. So imagine if you're 35 today, at what age you will get a green card. Now, till then, if you are I-140 is approved, you will get perpetual renewals. But if you lose a job, then you have 2 months to find another job. And that company has to file for your H1B, and only then you can stay in the US. Otherwise, you have to leave. So this uncertainty has been there for the last 50 years, and it will always be there. It's just getting worse. Now, to mitigate this uncertainty, the H1B visa holder has to have a green card, right? Now, an EB2 category green card gives you 40, 50 years, whereas an EB5 category green card, you can get a green card in 1 to 2 years. Okay, so a lot of people, especially from Indian backgrounds, are running to file for the EB5 category green card because they don't want to face the uncertainties, the risks, the renewal issues and stuff like that. So they know that if they get the green card, they do the investment, they are sorted. Okay. Now, a lot of people here in the audience might not know what is an EB5 based green card. In very, very simple terms, you invest $800,000 in the US, and additional expense of approximately $100,000 for the attorney, for US government filing fee and all of that. So today you need $900,000. In 1 to 2 years, you get the green card. And in 5 years, you can get your money back, the $800,000 investment. So a lot of people think that, oh, this is an expense. It's not really an expense. It's an investment-based green card. So the money is returnable, right? So that's the EB5 program. Its existence is since the early 90s. And a lot of people now have started filing, and people have taken the EB5 program absolutely seriously since, especially, the change in the regime and tightening of the laws. So laws were there, they are not tightened, they are just getting implemented. So yes, a lot of Indians are filing for the EB5 program.
Right. Thanks, Deepesh. That was a very interesting perspective on EB5 in response to the H1B uncertainties. I'm sure people are definitely doing their math well now, considering the H1B and the EB5, with a lot of things changing from a policy perspective on the EB5 too. So let's see what comes in store, what is in store in the near future. Purvi, I would appreciate your thoughts on what legal strategies should Indian nationals and companies employ to navigate potential visa and admission denials or processing delays under a stricter immigration environment. You're on mute, so.
Purvi, you need to unmute.
Sorry. So let's get into that now. So most businesses and most Indian businesses use 2 categories of visas. They use the H1B and the L1 visa, and those are the most popular ones. So I'm going to speak briefly about both these and what's happening in that field. So let's take the H1B first, then I'll go to the L1, and then I'll speak about the O1, which is an option. It's like a Brahmastra, but we'll touch that later on. So with the H1B program, what happened? So last year, before President Biden retired, he actually modified the policy on how H1Bs will be adjudicated, and they brought back third-party placement, itineraries, etc. So that change had already been introduced, but is being implemented under President Trump. Even there was a fee increase that was announced last year or the year before, but it was not implemented last year for registration of H1B workers. Up until last year, you only paid $10 per registrant, but this year you had to pay $215 per registrant. So that was a huge increase. And I think that it had a direct impact on the number of registrants. So in the last 2 financial years, we saw 780 and 760,000 registrants approximately. This year, there were about 460 or 458,000 registrants. So my view is that that drop was greatly influenced by the increased registration fee. So companies were earlier registering more employees for real work that they had, but because it was a lottery system, they were hedging their bets. But now they took a hard look at it because this can really ramp up the bill. So that has had a direct impact. Now we come to the adjudication. Yes, adjudication of H-1B petitions are subject to extreme vetting. You have to have detailed itineraries for third-party placements. Staffing company petitions are being scrutinized heavily. Staffing company postings require strict compliance with the labor condition application, which requires the posting of the notice at the end client site. So if you are a company that has a service agreement with a US company and your people are going to sit at their work site and work, it is imperative that they post the labor condition application notice in two prominent places for 10 days before an LCA can be included or certified and filed with an H-1B petition. So these are strict things, and they mean business. If you have employees that are working from home, the employee has to also post that LCA notice at home. Very often they ask us, but where shall we post it? We said, well, post it on your refrigerator, post it on your main door, post it where your guests can see it. It's a little awkward, but that's what the law requires. So you've got to do that. And now, earlier we've never seen this, but now we are seeing FDNS units and ICE and Department of Labor also visiting private homes. So if you have employees working from home, even they can expect a visit, so which was not the case in the past. But it's not a change of the law, it's just an increased enforcement net. So like Manoj said, that you need to brief your employees about what their rights are, what they should answer, what they should do, etc., etc. All companies are required to maintain a public access file for their H-1B employees. It is important that these files are maintained. You can maintain them electronically so that they can be accessed from anywhere, but otherwise they have to be maintained either at the headquarters or at the work site. We recommend online so that anybody can access it. Now, this public access file should be up to date, like Manoj said that they do, which is good. But you need to make sure that any change in the employee circumstances or in the corporate structure or in the payment structure should be notified to the public access file. In the sense, you write a letter and you include it in that, or you write a memo and you include it in that this happened. If there's a merger or an acquisition, in most cases, you can avoid filing new petitions and just do the public access file update. So that's very, very important. Now we come to the L1s. The L1s have always been difficult, but they're more difficult now just because of extreme vetting, especially the L1B, because that is only for specialized knowledge workers. I always tell my clients, you've got to think about your organization as a pyramid. If you have 200 people and you want to qualify 50 people as L1A or as L1B specialized knowledge workers, it's not going to fly, because that's a huge percentage. But if you're going to say that the top 3 technology people have specialized knowledge, that is a plausible story. That's a story that we can defend, we can argue, we can advocate. So you've got to really be careful about choosing your candidates, because otherwise the L1Bs are not going to work. You have to have a logical, plausible, explainable, evidence-supported case. Otherwise, you're going to find it difficult. After that, after the petition has been approved, which is relatively the easier part if you have a right candidate, the harder part is the interview. Many of the L1B specialized knowledge workers, especially out of India, are fantastic. They've got really the specialized skills, but their communication skills are not good. They're not able to articulate. They're not able to convey to the officer what they do. They're not able to convey to the officer that they are special. And part of this stems from the fact that we are of a community which is sabka mehnat tha, we all did it together. It was a group effort, team effort. Yes, that's nice. But at that point, at the interview, you've got to be selfish and you've got to show you are specialized knowledge. So you are the one that led the team to achieve whatever you achieved. So those are the type of things you need to take care of. Now we have consular processing resulting in a lot of 221G notices. When a case is put into administrative processing, you are issued a 221G notice by the consulate, and it could be of a different color. It could be yellow, green, blue. They have reasons why they have different colors. And in that, they will highlight one of the points on that sheet telling you why your case is on pending administration processing. Administrative processing can take anything from a few days to several months. And my advice to everybody is do not make inquiries before 2 months, because that's the published administrative processing timeline. So if you do that, you're just irritating the officers. They have lots to do. They are adjudicating 120 cases per day, each officer, and they really have very little time. So by bugging them with more questions, you're just irritating them, and that is going to result in more negative impact on visa issuance across the board. Not necessarily your case, but across the board. Now, what do? L1As, the managerial level, are doing much better than the L1Bs, but even there, you've got to make sure you choose the right candidate. Now, what do you do if you can't get these visas? There is an O1 visa, which is not subject to a lottery. And that can be granted. There's an O1A visa that can be granted to people with outstanding abilities in the business. And the criteria, they have 8 criteria, and if you meet 3 of those criteria, or your employee meets those, you could consider an O1 visa, which is really very good. It is not limited by 6 years. It doesn't have any prevailing wage requirements, etc. But it has another requirement which impacts salary. One of the criteria is they have to have a high salary, and you benchmark that not against the prevailing wages, but you benchmark that against industry peers. And then you can also get advisory opinions, etc., to prove your case. So O1 is something you can consider, but again, it is only for a selected few people in your company. What do you do to mitigate this problem? Look at localization, get more local staff to work for you. Manoj spoke about nearshoring. So think of options in the same time zone so that you can service your client in the same time zone. And of course, the use of technology. Technology is a game changer. Your business could still survive and be remuneratively, monetarily very successful without depending too much on human resources. So use a lot of technology. Yes, that's not good for employment numbers, but then the business has to go on. Thank you.
Thanks, Purvi, for the absolute detailed and the legal guidance based on your experience. I'm sure the corporate people who are listening to this will take a lot of takeaways from here. Over to you, Manoj. Manoj, have you already seen shifts in client sentiment to project timelines due to the uncertainty around the policies, US visa policies?
Of course, very much. And that's a very simple question to answer, so I'll keep it really short. You see, these delays in visa approvals, especially the H1B and the L1 categories, can definitely disrupt staffing plans. They can delay project kickoffs. And this is not just by weeks, but by months sometimes, So obviously, clients are not ready to wait for that long for a resource, right? So at times we do lose out on potential revenues. Similarly, I would say in the case of business visa also, when their issuance is delayed, there's an adverse impact on us. For example, our sales folks, they are unable to travel for business meeting or for conferences. Our delivery folks, they are unable to travel to receive training or to receive some orientation or for some knowledge transfer at the start of a project or something like that. All this, of course, is obviously seen negatively by clients, and it can lead to them looking for other vendor partners. So that's how we have seen the shifts happening in client sentiment. Yeah, I hope that helps. Thanks.
Thanks, Manoj, on your observations and insights. Over to Deepesh. Considering the tightening and investment thresholds rising, how viable is this path for Indian applicants today? The EB-5 path, I mean.
So yes, the investment thresholds will be rising always. So EB-5 program originally was at $500,000, and now it has been increased to $800,000. President Trump has proposed that they are coming up with a gold card program, which is going to be a $5 million investment. And they will, of course, either scrap the current EB-5 program or they will modify the amount to $5 million. So we don't know when that's happening, but that's happening for sure because President Trump himself has made the announcement. So given that scenario, if people want the green card, they have to do it today. I mean, when I say today, I mean absolutely today, because as I said, there is no timeline that they have given that this is the date or month or year when they are going to make this change. Now, for Indians, why it's important, and of course, the delays that are happening for Indians. Now, they have quota system per country. They give green cards. They don't give unlimited green cards for everybody. So whatever delays are happening, it's not because of the Trump administration. It's because of too many Indians filing for this green card. They give maximum 10,000 green cards per year under the EB-5 program, and there is a quota of 700 green cards per country per year, right? So imagine if 2,000 people file, then there will be a queue. So 700 will get in this year, 700 will get in the next year, and so on. So the delays that people are experiencing are because of this queue and because of too many people filing. Now, it's a very interesting option where, I mean, there are 3 subcategories of EB-5. I'll quickly throw light on that so it will become very clear as to what is backlogged and what is not. So the first category is called the urban EB-5 program. I mean, urban area, where in big cities, any construction, any business that's happening, there you have to invest $1.05 million, and there is a backlog of 4 to 5 years. Okay, and that backlog is coming from before. It's not a new backlog. The second category is urban high unemployment area, where it is still an urban area, but either that area has high unemployment rate or they are bringing workers from areas that are high unemployment. Now here you have to invest $800,000, but and you get the green card in 1.5 to 2 years. So they have given an additional advantage if somebody files in a urban high unemployment area. And the third subcategory is the rural area, where again the investment is $800,000, but you can get the green card in 8 to 12 months. It's absolutely fast, and they have given high priority and maximum quota for the rural area. So any project that's happening in rural areas, they get high priority and you get a green card in 8 to 12 months. So given this, the timelines currently, as I said, the first category is backlog by 4 years. But the second and third categories, as of the last visa bulletin that's issued by the US government, they are current. Which means if somebody files for these visas this week, this month, there is a very high chance that they will get the green cards in the timelines that I have told. But again, nobody can foresee how many suddenly filings will happen in the next week or so. So the uncertainty always remains. But if you want the green card, then this is the only hope. Otherwise, there is no point in waiting, even if there is a backlog, because at this price point, there is no other option to get a green card any faster. And once it changes to $5 million, I really hope you have this kind of money in your bank account. I pray for it. But till then, why not? I'll be happy if everybody has this kind of money. But till then, $800,000 you should be able to manage if you really want the green card. Also, a lot of people feel that I don't have this kind of money in my bank account, right? You don't need this kind of money in the bank account at the same time. There are a lot of places from where you can actually pull the money. Money can be used from your investments, your income, your wife's income, whatever investment you've done. You can take loan against property. You can sell your property and you can use the money. You can take loan against property. I mean, your parents can help you with money. The parents can give you money. Parents can sell their property and give you money. Your friends, relatives, even a neighbor can give you money. So it's a very, very flexible program where you can pull in money from various places. Money can come from India, money can come from Dubai, Singapore, or even US. So a lot of people think that, oh, I don't have this money sitting in my bank account. How will I do EB-5? But it is very, very flexible. US government cares about 2 things. One, that the money that you're transferring in the EB-5 program, is it a legit clean money? We call it source of funds. And second thing that they care for is your money creating 10 American jobs? The reason they're giving you this green card is because your investment is creating 10 American jobs. So these are the few things that I want people to remember. You should not worry about the backlog. If you want the green card, if you can raise this kind of funds, please go ahead and file for it, because it's just going to get more and more difficult.
Thanks, Deepesh, for the your practical experience and how what is dependency, etc., and how we should approach this EB-5 visas. Coming Purvi back to you, do you foresee any changes in the adjudication process at the USCIS or consulate that could raise compliance risk for the Indian applicants and employers?
Thank you, Nilesh. I think I addressed a lot of this already in my earlier response. I forgot I'm getting another question, but I'll still add to that. But before I do that, Dipesh, I don't want to say something contrary to what you said, but I do want to caution the audience. Whenever you're transferring money outside India to any country abroad, you need to make sure your transfer is in compliance with the Reserve Bank of India rules. And one of the rules that they have is that if you have taken a loan, you may not use it for LRS, that is the liberalized remittance scheme. So be careful when you do it. Yes, it's possible to structure loans outside the US for students, etc., who are living outside India and they're living in the United States, they're residents of the United States. Many of our H-1B people who are non-resident Indians, they take loans and they invest in EB-5 projects, same as that is students, because you first declare yourself as an NRI in India, then take the loan and then file the EB-5. But only when you're transferring money out of India, be sure you do it legitimately, because at the time of transfer, you'll get away with it. At the time of the petition adjudication also, you'll get away with it. But when it comes to the consular processing part, you may be questioned and end up into trouble because it may be considered to be in contravention to local law. So just be careful about that. But otherwise, yes, all the sources that Deepesh listed are possible, and we use innovative combinations for our clients very often. Now, coming to the adjudication process and the consular process, I think what's going to happen is that at the USCIS, we're already seeing it that they are issuing more RFEs, like Manoj said. They're also issuing a lot of notices of intent to deny. So let's say that they've vetted your case, they sent you an RFE, but they're still not convinced. They can send you another RFE, or we are seeing that they're sending you notices of intent to deny. What does that mean? That please clarify this question or that question or provide us with some evidence. Otherwise, we already have an intention to deny your petition. So when you respond to a NOID, we call them NOIDs. When you respond to a NOID also, you've got to give them a lot of information like you would in an RFE response. We are also seeing an increase in the issuances of NOIRs, NOIR. A NOIR is a notice of intent to revoke. This means that a petition has already been approved. They've given you the H-1B extension you wanted, but they have now come across some information that is incriminating or makes you ineligible for that extension. So then they're going to revoke that. But here also they're giving you a chance to respond and clarify. Now, when we talk about the L1B scenario, we've seen a few, and that's few, but more than ever before, notices of intent to deny extensions of L1s because the FDNS unit visited the L1 office and nobody was there. Or they visited the L1 office and the people over there said, oh, we don't know who this person is. We don't know. He's never come to this office. So that's a problem. So you've got to be careful that you are working from the work site that is listed on your petition. And if you're traveling for work or working from home for a particular day, your team knows who you are, what you do, and where you sit, what is your role in the company, etc. So HR or your receptionist or somebody should be available with knowledge to answer questions like this. So yes, you should be prepared for FDNS, ICE, and Department of Labor notices and visits. What we are seeing is also H-1B workers, when they are applying for their extension, like I mentioned, they are being called in because they have a past record, even if it's a drinking under the influence of alcohol. I'm saying even if it is, because that's a very common reason, very prevalent. And we were not seeing so much action about it in the past, but now we are seeing a lot of action about that now, in cases. When you have these remote workers, they need to be extra prepared, because if they're sitting around in pajamas at home and working at the laptop, Legally, it's fine. But does it look good? Now, when the ICE officers are coming or something, they'll generally give you a notice. They'll say, within the next 48 hours, we are going to visit your work site. If you get that as the signatory of the H-1B petition, alert your employees about this visit. They may give you a time slot, they may give you a window in which they will come, and make sure that your team and your workers are prepared for such visit. The last thing I want to say is they're using a lot of artificial intelligence. I don't have any official confirmation of that. We have anecdotal evidence from the legal community, not evidence, but anecdotal discussions from the legal community, and the large numbers in which they are doing things makes us believe that they're using artificial intelligence. For example, when they sent termination notices to thousands of students, like so rapidly and so widespread all across the nation, they probably ran the service records against some other government records and pulled them up. So we saw bizarre situations. I just want to share a couple before I move on. One of them was a student was studying in the United States, had a car, and he was driving. His lights were not working properly, his headlights. So they pulled him over. Now that's still a very big violation in America, but not enough to have a criminal record. But whenever they pull you over, they will ask to see your car registration details and your car insurance details. He pulled them out because he was confident he had it all, but his insurance had expired about 30 days before. They impounded the car, and when they impound the car, they take it to the police station and they have to make a police record. He went to the motor vehicles judge, sorted it out all within 24 to 36 hours, and got his car back. But his student status was terminated, all because of his insurance policy. So if a human being had looked at this case, they may not have sent him a termination notice because insurance was expired. But AI doesn't know that. AI doesn't have that human or emotional connection, or or it's not programmed to do these discerning assessments. So he got that notice. Another one got a notice because he skid on an icy road in winter, and he hit the guardrails at a railway track. Because there was an impact, it had to be reported. And when it was reported, there was a criminal record. I mean, there was a police record, not even criminal, just a police record. He also got picked up. So there are many instances like this that make us believe that it's not a human being making these decisions of termination, but it's AI that's making them. And the notices are going out automatically, is what we believe. So that's that for now, and I will be happy to answer questions. I have been answering questions online. Wherever you're posting it on the Q&A box, I'm trying to answer as many as possible. I'll be happy to take more as we go along, and over to you. I think Raghavendra, it's you now.
Thanks, Purvi. That was very precise, succinct, with expressing your views on the education process. Technology, the pluses, the cons, and the pros and cons of technology has been seen there currently by you guys, and possibly we'll see more coming out in the near future. Manoj, you had briefly touched upon this issue, but I would like to specifically ask you whether there is a growing interest in alternative geographies or nearshoring models to reduce dependence on the US visa routes.
Yes, like I said before, we use these in order to mitigate the risks associated with the current uncertainties surrounding the US visas. And the kind of alternatives that we propose to the clients are hybrid delivery models, wherein at least part of the work is done from offshore. And then, of course, the other one is the near shoring, which Purvi also spoke about, wherein the work is done from a nearby country like Canada, maybe, where the time zones are almost similar as the US. But then again, see, making these models work needs planning, and it also needs lead time for execution. Secondly, the success of these alternate models like hybrid and near shore, etc., depends on factors like what is the exact near shore location and the alternate costs at that location, right? So these models are there, but they're not necessarily a sure shot solution. But yes, they do mitigate our woes to some extent. Having said that, I also want to state that it's not all gloomy out there. The US continues to value skilled talent, especially in the IT sector. There's growing bipartisan recognition of the need for high-skilled immigration reform. So let's hope we can see some things easing out in the near future for Indians aspiring to travel to the USA.
Thank you, Manoj. Dipesh, you did touch upon this particular question earlier, but just in case you want to add something, what impact could Trump's second term have on the EB-5 program's backlogs? You did mention about the backlogs and how to go about and the processing speed, especially for Indian investors. Do you want to add anything to the earlier response? I think that's...
Yes. So in fact, see, there are two kinds of people who would want to do EB-5. One is who are already on American soil. So F students, student visa, H-1B, L-1, all these are people who are already living in the US, and they don't want to go through the hassle of how to get the green card, right? And the second kind of people are people who are living outside US soil. Now, there is a very big advantage for people when it comes to timeline, the advantage for people who are living on US soil. So let's say it takes about 1 month for the attorneys to look at your source of fund and approve the source of fund. That means, okay, we've seen your money, your $800,000 are clean. USCIS will accept that money. They transfer the money and we file for the I-526E application, which is the US EB-5 green card application. Now, if you're on US soil, we will also file a concurrent filing of adjustment of status, and you will get work permit and travel permit in literally 4 to 6 months. We call it the virtual green card. After that, even if it takes 1 year or 2 years for your green card to come, you can live, you can work, or you can even travel in and out of US. So that additional advantage is given to you because you're on US soil. If you're outside US soil, let's say you are in India, and if you file and it takes 2 years for you to get the green card, that means once you get the approval, you are already in India. It takes whatever 4 or 5 months for you to get an appointment at the Mumbai consulate, because Mumbai consulate is the only consulate in India that adjudicates green card cases. So you take an appointment, go there as a family, visa interview, and then stamping happens, and then you fly to US. So that timeline becomes a little longer. But if you're already on US soil, you have an additional advantage, because after filing, let's say in 1 month's time, literally in 4 or 5 months' time, you'll be free from whatever visa you are living on. So that is an additional timeline benefit for people who are already living on the US soil. Right. Other than that, I've already spoken about timelines.
Yeah, absolutely. Yeah.
Within 1 to 2 years, you can get this green card. Oh, one more thing I would like to add, because a lot of people are worried that as President Trump has announced that he will either scrap this program or change it to $5 million, what if I invest now and if the program changes? All right. The law is very, very beautifully written. It says that if you file for your I-526E application, and even on the next morning, this law gets scrapped totally, you will be grandfathered into the original law, which means the law existed when you filed, so that law applies to you. So that's a very big advantage. So anybody who's thinking of filing, just file it. Don't worry about whether in future it will get scrapped or no, you will get the green card. Second, there are some regional centers which give you an additional breather. So EB-5 law says that you have to file only after you invest $800,000 and if you paid all the fees, right? Filing fee, attorney, all of that. Which means you need all the money ready today. But some regional centers might give you a relief and they'll give you a deferred payment option. As long as you put, let's say, $200,000 in the project and you pay all other fees, obviously the filing fee, attorney fee, all of that, you can start your EB-5 journey. You can actually file for your EB-5, and the balance money, they might give you 2 months, 3 months, 4 months, depending on the project deadlines. So there are certain very interesting customized workarounds we can do for people so that they'll get this relief from, how to bring this money and the timeline problem. Over to you.
Great. Thanks.
May I add to that?
Yes, Purvi. Yeah,
so what Dipesh says is really fantastic, because when you do the partial investment, you've locked in your position in the queue, which is very important, because if retrogression comes, locking in your position is very beneficial. So I saw there was a question that Deepesh just addressed the question that if you're short of funds, what can you do? You should do you should file even with partial funding, and then quickly, arrange the other funds and file. Lock in your position in the queue.
Thanks for the supplement also, Purvi. Just to re-emphasize what Deepesh said, thanks a lot. Just one final, a common question to all the three. I would want you to go one by one. What key advice, before we go to the audience questions, what key advice would you give to Indian businesses, professionals, and students planning US travel or operations in the next 12 to 18 months under the current immigration climate?
Who do you want to start?
You can start, Purvi.
Okay, we stick to our same sequence. Okay. So, travelers to the United States, first of all, don't be fearful. Don't be afraid. And when you're going for a visa interview, also don't be afraid, because in the chat, in the question answer box, I see many questions about 5 tips to apply for your visa, 5 tips to get your student visa, etc., etc. So these are some of the things that are going to apply for everybody. So I'm just going to address the questions and your question right away now. So there are 3-4 things you need to keep in mind. When you apply for your visa or when you arrive in the United States, you need to be able to clearly articulate what is your purpose of travel. If you're coming as a student or as a business traveler or as a tourist, you've got to be able to convey that you're going to return to your home country, wherever you reside. It may be your country of nationality, it may be another country where you're residing. But you've got to have strong social and economic ties to that country, and you should be able to convey that to the officer clearly. Visa interviews are not document based. They are based on your personal interaction. So what you say to them is way much more important than a bag full of documents. So remember that. Even when you arrive in the United States, you may have a stash of documents in your hand luggage. They're not going to look at it. They want to talk to you. But the documents in your hand luggage are going to help you establish your story if you have additional questions. So first of all, don't be fearful. Do what you're supposed to do. Make sure you have enough money to cover your trip. Earlier, they were not asking for proof of return tickets, but now we have seen very random instances where officers, when you arrive in the US, are asking you, oh, you're leaving in 2 weeks, can I see your ticket? So be prepared to show your ticket. Going to the United States for your daughter's delivery is not a permitted activity on a B2 visa. You're going to be with her to offer her emotional support, yes, but to help her with the delivery, not permitted. So be careful about what your purpose of travel is. Most mothers go there for support and not really to work as a maid. So you've got to be able to convey that clearly. For business travelers, make your trips short, precise, and very, very well documented. So have a meeting itinerary. Make sure that the person whom you're going to meet is reminded about your arrival in the US, because we have also seen recent instances where officers are calling up the person whom you're going to meet and saying, oh, you have a meeting with Mr. Balwani on June 25th. And he'll say, oh, I don't know. And we are in trouble. So we don't want to do that, Manoj. Make sure your meeting person is aware of your arrival. And these are things that you need to be careful. There are lots of people who go for trade shows and jewelry shows, especially the Las Vegas jewelry show, etc. Those people also need to be careful. You're allowed to go there and participate in the exhibition and trade fairs, but you cannot conduct business there, in the sense you cannot, if you have an American company, you cannot be booking business in your American company. Your trip has to be for the benefit of your Indian entity and not for the US entity, because if it is for the benefit of your US entity, you are unlawfully doing work over there. You're unlawfully employed. So don't do that. People miss this. They say, oh, we went there, but we booked the business in America because it's easier for those people to pay us. But that's a big no-no. And there are many things like this. There were questions about how do you install how do you go there to install equipment? There's somebody in the chat who's asked that question. You can use a B1 visa for that, provided it is part of your contract, your sales contract, that you will also offer them a service on that. It is there in the Foreign Affairs Manual, which is the Bible that visa officers have to look at. So you read the FAM provision, it's the Field Affairs Manual, it's the FAM. Read that and see that there is a provision where you can, officers can grant you that visa. So being prepared, being informed, taking advice from people who know more than you or who have more experience is very important. So that's my 2 bits advice to everybody.
Thanks. Manoj, anything further to add?
Yes, I think Purvi has covered it so very comprehensively, but I would probably just add a few words. My key advice would be, as Purvi said, stay compliant, prepare early, and also remain flexible.
Yes.
For businesses, I'd say this means strengthening internal immigration processes, ensuring documentation is airtight, and working only with vetted immigration attorneys or partners. For professionals and students, I'd say it's important to understand the scope of your visa, maintain transparency in your application, and also allow some extra time for processing. You see, the US still values skilled talent, especially in sectors like IT, but the bar for compliance and scrutiny is much higher now. So being proactive and well informed is your best strategy in the current climate. Yeah.
Thanks. Dipesh, anything further to add from what Purvi and
No,
Manoj said?
they both have actually said everything that they should. I'm going to add a couple of examples of. So I recently got a lot of students who were either not allowed to enter the US or they were asked to leave. So their parents booked a consultation with me, and I spoke to them individually. I mean, they're not like a group of students, but so the parents said, we paid the whole year's fee, and this is so wrong, and what has my son done, and all of that. But when I spoke to the kids, when I saw the documentation that was given to them by the US government, all of them had either worked illegally on cash and they had the proof. Couple of students did not attend enough lectures that they should have attended by law. So these laws existed. I did my MBA from US and those laws were there even then. And during the orientation, we are very, very clearly told that these are the things you can do. These are the things you can't do. Now I understand the American dream. I understand, the students want to make money and on the side and all of that. But that is illegal. So if you do that, and then you cannot blame the government saying, oh, why don't they understand our situation? Because when you got the I-20, you showed them somehow that I have the money. If you showed them the money, they will not understand why are you trying to work illegally to get additional money. So though the media says, oh, they are firing, they are removing all H-1B students and stuff like that, there is a reason. They'll not just remove any student randomly. There are universities that we know of that are in 2 rooms, 3 rooms, and they have 5,000 to 10,000 students enrolled. So imagine what's happening, right? So just be cautious. Don't get caught into such wrong universities. If your kids are there studying, please tell them study, do what they are supposed to do on this visa and not try any stunts. Otherwise, they are facing repercussions. It's really bad. I feel bad. But if you've done something wrong in the eyes of law, you will face the brunt. Also, when it comes...
After you, sorry.
And also with EB5, whoever is ready, that they know that I want to stay here for a long term, please, you'll have to go ahead and do the filing, because this is the only hope. Don't think, oh, it's going to take time, whatever, because next step is $5 million, and that is happening. In the last term, President Trump had increased the $500 million threshold to $1 million. Again, he's the president. So in the last term, when we used to talk to our clients and say, oh, it's going to increase, people would say, oh, this is all marketing gimmick. Aisa kuch nahi hone wala hai. But it went up. This time, President Trump himself has announced about the gold card. So we know that it's coming. So if you guys are serious about the EB5 program or staying in the US, EB5 is the only option you have. All right. So with that, Purvi, over to you.
I just wanted to say, I wanted to remind everybody or tell people that a visa is a privilege. It is not a right. So if they deny you a visa or they cancel the visa, that is their right. We deny the Indian government denies visas to many people to come to India. At that time, we are not complaining because a visa is a privilege, not a right. Be careful. As a don't demand a visa, request it.
Well said. Yeah.
Well said. This thing I want to take home from what I think all of you said is for the audience, at least in the US, here somehow culturally we have said, okay, some small mistakes we do is acceptable, not acceptable. So that's a complete no-no. In US, cannot do any, you assuming a law is there to follow the law to the T. If people have gone scot-free till now, that's their luck. But please don't do anything which is, not acceptable to the which is not as per law, not acceptable.
Correct.
We have got another 10 minutes to go. I would want
Yeah.
Vishnu to quickly run through the questions. If you have covered it, I think we may skip it. I'll leave it to the panelists to decide that, but quickly, sort of to the extent possible, let's do that.
Absolutely.
And otherwise, I think we'll request the panelists to prepare a response, and we'll write back to the people who raise the queries if time is not there. Yeah.
Yes, sir.
Over to you,
Absolutely.
Vishnu.
Yes,
Yeah.
yes, sir. Thank you so much, sir. Absolutely. What we'll do is, if the questions are not answered in this frame time, so what we can ask is we can give them an email later on, and we have their email address and the questions with us. Just to highlight, thank you so much, Mr. Rani, Mr. Balwani, Mr. Deshmukh, for your detailed insights, what we've got. And we've over 25 questions here, just to keep, within the timeline. What I'll do is I've randomly shortlisted few of them here for now. I'll just shoot out the first question for, whoever wants to take it, please go ahead and, you can answer it. What is the visa process for existing B1 visa holders in renewing or extending B1 visa before the expiry date? What would be your inputs for this? Yeah,
Shall I take it?
please. Yes, ma'am.
Yeah, so if it hasn't expired, or it expired within the last 12 months, you are most likely going to be eligible for Dropbox, and the system will determine that. So when you start your visa application process online and you answer certain questions, there's an algorithm which will decide, oh, you are a Dropbox candidate. Then you just drop off your application form at a visa application center at a VAC, and they will send it to the consulate for processing. When you choose when you do the Dropbox also, they will still ask you which consulate you want to go to. You don't want to go to a consulate, but you still have to choose one, because after you apply under Dropbox, if the consular officers need to speak to you, they have the right to still call you in for an interview. But most cases with clean records get adjudicated in the Dropbox very quickly. Within about 2 weeks, you should have your passport back.
Yeah. Perfect, ma'am. So again, coming back to the H1B visa question, what would be the risk of deportation an immigrant that carries if he has a speeding ticket which is 3 years ago? So, and that is a single instance. So that's a question which we received, and yeah.
It can still be revoked. It can still be revoked. So usually it is the type of, if it's a small offense and long ago, they are more lenient. But if they are relying on artificial intelligence, this one will definitely be picked up. So speeding tickets are really not a criminal violation, but they will be put to questioning, or they may be called for fingerprinting. So I don't think it will be revoked, but I think there will be certain action.
1 second, sir. Okay. Dipesh, this could be for you. There's a very little time, and he's falling short of funds for AB5. Can you suggest if there are any funds available that he or she can avail? That's a question.
So that's a very common question, and surprisingly, yes, there are certain regional centers, or rather certain projects. There are some lending institutions in the US. They've vetted the projects. They know the developer is good. They know that the money is safe. They know that the project is really, really good. And they can give you up to $300,000 of collateral-free funds at about 6%. And you return the money after 5 years, or after whenever you get your $800,000 back. So these so they are very rare. It's not very common. But if you do enough research, or I have access to some of these kind of loan options. So this becomes very, very big help to people, because now instead of 800,000, they have to worry about 500,000, 300,000 without any collateral. This is predominantly for people who are already currently living in the US, right? So this is an additional thing, and of course you can use the deferred payment option, where you pay $200,000 now in the project and defer the payment by 4 to 6 months, depending on the project timeline. So that should help whoever asks.
Yeah, absolutely. So there's a student who's written, I'm a student, H1 approved, but stamping is still pending from October 2024. How many days are allowed if he or she loses a job in between?
That Manoj, do you want to answer that? Because that depends on company policy.
Yeah.
Correct. Yeah.
It's nothing to do with immigration law or employment law. It is pure company policy, because in America, most states have the practice of employment at will. What does that mean? That within minutes they can terminate you for no cause. They don't have to show anything and they can terminate you. So that's why we see in movies, etc. You go into an office and they give you a pink slip. That is the short form for termination at will. So there is no time limit. Manoj, did you want to add
Yes.
to that? As
Mr. Balwani, yeah, you
So
would
you're
want to-
right. You're right, Purvi. Nothing to add. Thanks.
Perfect. Again, from a question from a student point of view, I just want to understand what is the impact of student going to study abroad. If US looks scary, what is the next best option for the students that they are choosing? Would you want to answer something like this? Yeah.
Dipesh, not me.
Oh, you chose me so that I can give the dangerous answer, right?
I think we should not
No,
respond to this. We are not.
I think you must
We
be
are put in
having
your spot,
I'll be more
alternatives.
than happy to respond. I'll be more than happy to respond. See, frankly, I'm not comparing any country, but
Yeah.
US is US. I mean, when it comes to education, all you should worry about is doing the right thing. If you're doing the right thing, you don't have to worry about anything, right? So from that perspective, US still remains number one choice, whether it is studying, whether it is working, or whether it is permanent residency. And yes, if US seems difficult or whatever, then there are so many other countries like Canada, UK. In fact, a lot of students are these days studying in Dubai. Good thing, especially kids who have not used to staying away from parents. It's just 2.5, 3 hours away from India. So you can come and visit over the weekend. Your parents can come and meet you. It's very easy for parents to come and see you. So Dubai has suddenly opened up. A lot of US, UK, Canadian universities are based in Dubai. A lot of Indian universities have moved to Dubai. So a lot of people will not think of Dubai as a study option, but I have recommended a lot of people and it has worked. They are very happy with that option as well.
I didn't know about Dubai.
Yeah. NYU is in Dubai and a lot of other US. And they
What
also...
about European countries, Germany, etc., are also offering programs in English? Are they popular?
See, yes. But the problem is with Germany, if you do a English taught program, it's very difficult to get a job.
Okay.
And a lot of engineering students, they start studying German the moment they get in the first year. So they become comfortable with German and then they take the German taught program. If you do that, then you have much higher hope. But again, that's predominantly for engineers. I mean, some people do MBA in Germany and I don't know why, because, like I would buy a Swiss knife only because it's Swiss knife and no other. So similarly, engineering, yes, they should focus on Germany. But if it's a German taught program and if you're fluent in German, it will definitely help you. But otherwise, language barriers are tremendous in Europe.
Can I request, in the essence of time, we're just 3 minutes away.
3 minutes.
There are a lot of questions which are remaining unanswered. Can I request the esteemed panelists that, maybe later on over the weekend, if you can just have a look at it and we'll respond back to the participants. It has been a fantastic, panel discussion. I would request my esteemed Vice President Raghavendra Pongshe to, propose the hearty vote of thanks.
Thank you, Nilesh Bhai. Namaskar. Good evening once again, ladies and gentlemen. As we come to the close of today's insightful and highly relevant session on US visa barriers, impact on Indian travelers and businesses, it is my privilege to extend a heartfelt vote of thanks on behalf of the IACC West India Council. Let me begin by expressing our sincere gratitude to our distinguished speakers, Ms. Purvi Chotani, Mr. Dipesh Deshmukh, and Mr. Manoj Balwani, for their time, expertise, and in-depth perspectives. The clarity with which you have unpacked complex visa frameworks, legal nuances, and the broader strategic implications for Indian professionals and enterprises has added tremendous value to all our participants. A big thank you to you all participants as well, a mix of professionals, entrepreneurs, students, and policy enthusiasts, for joining us from across geographies. Your interest and engagement reinforces the growing importance of forums like these that will navigate cross-border challenges with clarity and collaboration. My special thanks to my president, Nilesh Vikamse, for spearheading impactful initiatives like this under the IACC banner. Nilesh Bhai, Your dedication forms the backbone of successful sessions such as this one. And of course, I would like to appreciate the efforts of our IACC Secretariat team, Vishnu and Dhanashri, for their seamless execution behind the scenes. At the Indo-American Chamber of Commerce, our mission is to foster meaningful dialogue, drive bilateral cooperation, and support our stakeholders through evolving landscapes, economic, legal, or regulatory. Today's session is yet another step in that direction. We hope all of you leave this session with valuable insights and actionable takeaways, and we look forward to continuing these important conversations in the months ahead. Thank you once again and have a great evening.
Thank you so much, sir. Thank you.
Thank you, everyone.
Thank you so much. Thank you, guys.
Vishnu.